Good afternoon, everyone. Thank you so much for being here. My name is Kelly Beard, Content Specialist for Maryland Realtors. I want to welcome you all to our Broker and Office Manager Forum. Our CEO, Chuck Caskey, and Legal Associate Taylor Kitzmiller are going to dive right into these new forms. This webinar is going to be recorded and it will be shared. We do encourage your questions and we look forward to answering them. Please post your questions in the Q&A box below at the bottom of your Zoom screen. We will answer your questions after each form is reviewed, and then we will have time at the end to answer any additional questions. With that, I'm going to turn it right over to Chuck and Taylor. Chuck, take it away.
Thanks, Kelly, and thanks, everybody. We know we just opened the session and then got right through there, through the intros. I see from the counter that people are still joining, so I'm going to just give a minute or two. Just take my intro a little slowly. I think it seemed to have stopped. So great. We have a lot of people present. They'll be coming and going. See a lot of familiar names, so welcome. Thank you guys for participating. Thanks for being, I guess, receptive. Big changes are coming. We know that on the one hand, that life as we know it is really going to change on August 14th. On the other hand, one can take the more positive approach and say, yeah, we're just moving some things around and the dynamics of the industry aren't really going to change that much. So we're hoping to take the latter, position here and say that, yeah, a lot of this is new, but it could actually end up being better. And so once we adjust to these new realities, I think we'll be better off in the long run. I really do believe that. So a little bit, as Kelly mentioned, we have the Q&A. The chat is disabled, but put questions in the Q&A. If we get to a point where there are questions that are several parts or follow-up, I won't be afraid to promote people, or not promote, that's the wrong word, but at least authorize people to speak. And but I reserve the right to shut you off if the questions are too long-winded or not productive to the overall discussion. So with that caveat, if there's a pressing question that you don't feel could be in the Q&A, then we'll allow you to ask your question live. But again, with the caveat that I reserve the right to cut you off. So, and as you know, I'm not afraid to do that. Thank you. Jean already has a good question. I have no idea what form. We're going to take these forms in order. So the cooperative compensation form will be later. So we're going to save that question. So why don't we do this? We're going to go through the forms one at a time. We're going to stop at the end of each form. So we're going to start with the listing agreement, for example, and then ask questions about the listing agreement. Sorry, Taylor, we're listing agreement first.
Listings first.
And then we'll take questions on the listing agreement. And if you have overall questions, we could save those to the end. But specific questions on specific forms, ask them while we are talking about that form. We're going to get to all of them. So 5 new forms. We'll go through every single one individually, talk about how they all work together, for example, and then take questions on each form as we finish up the description of the form and the practice tips. And then at the end, we'll have some overall questions, thoughts, and wrap up. Okay, so I see Jean's question on that form. We're going to save that question for when we are discussing that specific form. Okay. We seem to have reached the limit of the amount of people. So this is a training exercise. Excuse me. As you know, you guys are, by definition, and I'm looking at the names, really good to see a lot of you, brokers and managers who are really going to be on the front lines here. And you are going to be responsible for training in the next 6 weeks, really training the agents in your offices on the new reality and the new forms and what Bright is going to look like and how to have these conversations, different conversations with buyers and sellers than we are used to having. We acknowledge that. And we also acknowledge that we are here and hope to provide as much support, as much information, collateral, educational materials, assistance, and that kind of thing. And toward the end, I'll tell you exactly what we plan to do to help in that. So you have the forms, you have the practice tips. We're going to be you have the videos that Taylor and Diamond did. So that's a good start. We need to start training now. We need to get agents in rooms and have them practice role play. What do these conversations with buyers look like? What do this conversation with sellers look like? How do I fill out these forms? There are more forms than there used to be. How are they all going to use? How are they all going to fit together? So that's what this is about. This is about us keeping our promise to you that we would give you at least 6 weeks lead time before the effective date to get this training underway. And we're meeting our obligation and our commitment to you. And we are going to be here. We'll come and visit you. I've already, every other day, Taylor and I, Diamond, we're out there, whether it's on a call or an office visit or a local board visit. We are here. My calendar's filling up. Taylor's is filling up. But, please let us know. Email us. I was at Women's Council today. I was at Midshore on Tuesday, and we're here today. So, we are not afraid of coming out, talking, having these difficult conversations, okay? So, but you are on the front lines. It's going to be up to you as brokers and managers to really do the heavy lifting as far as this training goes. There will be forthcoming 2 additional forms that are amendments to the brokerage agreements. So both the buyer representation agreement and the listing agreement, as they exist today, are in need of slight amendments. And you'll see the changes being made to both of the brokerage agreements have to be updated. So your existing forms will have to be updated by August 14th. And so you can get those signed anytime to be effective on August 14th, making the changes. You don't have to enter into brand new brokerage agreements, but you will have to have the clients, buyers and sellers, sign the amendment. Taylor's working on that. We're going to have it done next week. It's only going to be a couple pages. The listing agreement might just be 1 page, I think we said, maybe, Taylor, is that right?
I think the buyer agency is going to be 1 page probably.
Buyer agency is more simple. That's right. The listing agreement could be the pages could be 2 amendment. The amendment could be 2 pages, but that's important. So to keep your eye on that, and we will get that out to you. You will have to have that signed at any time, effective on the 14th. Okay. So, and we'll make all that very clear to you when we release those forms. The other caveat is the forms we're going to go over today are in draft form. The watermark is on it. If you print it out, it will say, it'll say draft. We don't mind you printing those out for your agents. If you try to fill them out, it won't save. And so we advise you to be careful to not start using these forms prior to the 14th, but certainly use them for training purposes. There almost certainly will be, and we'll point out at least one that we know of, where there's a small discrepancy between the form, the listing agreement especially, and the Bright policies. So it's on the coming soon, and we'll show you what that is in a minute. So there will be slight differences between what you're going to see today and what you have already received from us and the final versions that are going to go to the vendors. Lone Wolf just said that they want these forms by July 1st. I'm not sure we're going to be able to do that, but we're in negotiation with them, and we'll get them the forms as soon as possible. I can't even imagine the volume of work that they're going on to keep ZipForm up to date and be ready for the launch, the effective date. So we're going to do what we can to get those forms to the vendors well enough ahead of time so they have an opportunity to update their libraries a couple days before the launch of October 14th. I just want to, well, no, I'm going to save that. I have one more comment, but I think I'll save that for later. Other than that, Taylor, well, Sharon, okay, that's a good question. Are we considering a pause in light of DOJ filings? The answer is no, there isn't a, no, the answer is no. First of all, the DOJ filing is a, I think, a misleading word. They sent out an information request to California Association. Based on the Consumer Federation of America comments on the buyer representation agreement, not even the listing agreement. So please keep that in mind. And I have some intelligence that says that the Consumer Federation of America has a specific or a separate report on the California listing agreement. We have not seen that. We don't know what it says. We do know kind of where people seem to be headed. We can talk about that closer to the end. But no, we are firmly committed to these forms, again, with a couple of tweaks maybe, but we can't wait. I mean, if we have to, something happens, we'll deal with that. But at this point, no, we are inclined to just go full steam ahead, get these in your hands, and you can start training now, because you need as much time as you can get, and we are providing that to you. So as of today, the answer is no, we are not anticipating a pause. So with that, I'll turn it over to Taylor, and he can start going through the forms one at a time. And again, after he presents the forms and the changes, then we'll take questions. Taylor?
All right, thanks, Chuck. Share my screen. Before we get into the actual changes, I just want to give a shout out to our statewide forms committee. I staff our statewide forms committee, and they've been working tirelessly on these changes since last October. And then, even more so after the settlement agreement. So I'm sure we have some of those members in here. So shout out to statewide forms committee for really putting a lot of effort into making these changes happen. Okay, so like Chuck said, we're going to start out with our listing agreement, the exclusive right to sell residential brokerage agreement. The first change we made is really just a language preference change. It's nothing substantial. Previously, we referenced the length of the listing agreement as the listing term. We've decided to replace that with just agreement term. So just for more clarity, and all these changes you see here are that exact change, replacing listing term with agreement term. Okay, these next couple of changes were made in response to Bright MLS policy changes. The first one here was made because of the new disclosure form required by Bright, called and it's right here, called the MLS Disclosures and Residential Seller/Landlord Options Form. Essentially what that form is the seller and listing broker enter in a date upon which that property will be entered into the MLS, number one. And number two, they have to specify what status that property will be entered into the MLS as. So active, coming soon, or office exclusive, and whether or not that seller wants the property to be distributed on the internet. So Bright requires that form to be submitted to them, and they also require that form to be executed at the same time as the listing agreement. So we've added in this sentence stating, upon the execution of this agreement, seller and broker shall establish the date and status upon which the property will be entered into the MLS by executing that new form. Okay, next change. This is a pretty minor change. This boxed in paragraph currently exists in our listing agreement, and it is the office exclusive paragraph, where the seller authorizes the listing broker not to have their property distributed on the MLS. So other MLS participants cannot see the property. Changes we made, we added in a header here, just so listing agents, listing broker, and their clients understand this is the office exclusive paragraph. The change here was just made to mirror the wording that Bright uses. They used to say, seller may elect not to have the property listing displayed on the MLS. They've now changed the word displayed to distributed on the MLS. So we just wanted to, stay in compliance with Bright's terminology. So that's why we made that change. Other than that, yeah, no other substantial changes to this office exclusive paragraph. All right, next change was made to the coming soon paragraph. And this is because previously Bright had a rule that if the property was submitted as a coming soon, then that agent had to submit an expected on market date no later than 21 days from the point where that property was submitted as a coming soon. Bright has now removed that 21-day restriction. So my understanding is if you submit your property as a coming soon listing, it could be in that status for forever. There is no 21-day requirement anymore. So we've removed that reference to the 21-day rule. Also, at the end of this paragraph, it used to state, however, properties listed under the coming soon status may not be shown and are not syndicated to public real estate websites. That's no longer true. If the property is submitted as a coming soon, Bright will syndicate it to other public real estate websites. So we've removed that portion. All right, the final change caused by Bright policy change was this inclusion of the seller concession paragraph. So Bright created a brand new seller concession field on the MLS. Everything you see here, every word mirrors exactly what that field looks like on, on Bright. Essentially, what the seller concession paragraph is it allows the seller to say whether they will consider requests from a potential buyer for payments towards closing costs or seller concessions. This is an optional field. But if the seller does want to fill out the field, they can say, no, I will not consider a request for closing costs, or they can say yes. And they have a second option. If they say yes, then the seller down here can specify seller will consider closing cost payments / concessions up to a certain percentage of the gross sales price or a certain dollar amount. So if you're a listing agent or broker and you fill out this section with your seller, it's easy, you just go straight to Bright. This form will look exactly, the field will look exactly the same, and just input the information, whatever's in here, input that into the field on Bright. And we also have an initial section, so the seller acknowledges that they have read this portion of the paragraph, of this section. Okay. So now we've gotten past the Bright changes. Now we're looking at some changes to our broker compensation paragraph. First off, the notice section here. The first sentence actually currently exists in our brokerage agreements. Real estate commission rates are not fixed by law or established by any membership organization with which broker is affiliated. But we've added 2 more sentences, and the last sentence was actually specifically required by the settlement agreement to be included in brokerage agreements. So they state each real estate brokerage independently sets their own commission rates, and commission rates are negotiable between the seller and their seller's broker. Next change, which is somewhat significant. Currently, this portion, the compensation paragraph where the seller states, I agree to compensate my broker what X% or X dollar amount, is currently a blank paragraph. During this past legislative session, a law was passed to now require brokerage agreements to state compensation in one of these 3 ways. That law will go into effect in October, but like Chuck said, these new forms will come out in August. So with your clients, they're going to have to fill out and agree to compensation in one of these 3 ways: percent of the sales price, and a dollar amount, or a dollar amount. Also, a requirement from the settlement agreement, compensation that is agreed to by a client and their broker must be ascertainable, and it must be an ascertainable amount. In other words, you can't put things, this would apply to the buyer broker agreement, for example, per MLS. That has not been allowed in the past, and it's certainly not allowed moving forward. It has to be an ascertainable amount that is entered into this section. Okay, next change, somewhat of a minor change. This used to be the authority to cooperate with other brokers paragraph. Now it is the authority to cooperate with and compensate other brokers paragraph. First change was really just a wording change. It used to say brokers shall be entitled to cooperate with other brokers. We decided to change that to broker is authorized to cooperate with other brokers. It's just a stronger, more assertive wording there that the broker is authorized to cooperate. Also, the change here, we used to reference they can cooperate with buyer agents, but that's technically not the accurate term. These are cooperation and compensation agreements between brokers, not between agents. So we've replaced buyer agents with buyer brokers. Next, we realized we didn't have a definition for what cooperate actually means. And one of the main goals we had for all of our revisions to all of our forms was to make them more easily understandable for an average consumer, a first-time home buyer, first-time home seller. Make it so if they are reading these agreements, they fully understand what they mean. So we've added in the definition here. In this paragraph, cooperate means sharing information on the property and making the property available to other brokers for showing to prospective purchasers. The final change we made was we used to reference a fee sharing between subagents or the seller's broker and subagents and buyer brokers. The more accurate term is not fee sharing, it is compensation of subagents or buyer brokers. So that's why we made that change as well. Okay, final two changes we have here. This is a new paragraph. Again, this is in our compensation section. It states, broker and seller shall execute the listing broker's offer of cooperative compensation. That's a new form that we'll touch on in a second. And seller hereby authorizes broker to share the listing broker's offer of cooperative compensation with buyer brokers and subagents. And we've also added in another initial section so the seller acknowledges that they have read and understand paragraph 15. Final change we made, final change is just adding that new form, which we'll touch on in a second, to the list of addenda to the listing agreement. Okay. Now we can address some questions before we move on.
Yeah, so while you were doing that, I answered some. I think they're good. Some of the questions are coming about Bright policy. And so we hate to do this, but you're going to have to ask Bright a lot of these questions. They're setting policy. We are putting out the forms about to reflect to the extent we know what their policies are, especially as it relates to what the fields are and how you input the information into Bright. And we are making sure that our listing agreement mirrors Bright's policies and fields for the facilitation of inputting the listing information. Questions on what the rules are for office exclusives, things like that, you're going to have to direct to them, okay? Because there are some things that are changing and have changed, but they are responsible for their policies. We will not be answering questions about Bright policies. There's a question about the form, the input form, that's on their website. So you can go, they've blanketed, you should have received emails from them. All subscribers, I thought, received an email from Bright, but I know for a fact it's on their website, so you can always go to their website. The question about, well, no, I'm going to skip that. Somebody, an anonymous attendee said, allowing CS, but no IDX feed. Please clarify. I'm not sure what CS means.
I think what she's getting at is there's an option for the property to be submitted to Bright as a coming soon.
Oh, coming
No
soon.
IEX feed, which means they're not going to share it on the internet.
That's right. I'm sorry. CS coming soon. Yes, there
Yeah.
are two options. I saw a flow chart of theirs, and there's 5 options, and that's what that input form will be to have you. And that's why Taylor mentioned we took out that that phrase from the coming soon paragraph, because in fact, coming soon you will have 2 options, not just the fact that the 21-day period is missing or being removed, but there are 2 options, one with internet distribution and a coming soon without. So not just coming soon, but 2 marketing options. Right. Thank you, Taylor. CS coming soon.
Mhm.
Admin fees. This is a couple of oh, you're typing it, but let me answer admin fees. I've had a love-hate relationship with admin fees. I would recommend if you are still charging an additional fee on top of your quote unquote commission, it's our position has been for decades now that it's all compensation. It says compensation. And you can call it what you want, but if you are charging a fee and calling it something else, you run a risk of running afoul of RESPA. And we have always recommended that you just incorporate that into the blanket concept of your compensation. If you want to call it something else and you say it's to pay for something like office administration or filing, maintenance, or anything like that, and you are sued by the federal government on a RESPA violation, you're going to have to actually show that you provided those services for that fee and that the fee was reasonable given what you have charged for it. So we have been advising against that for many years now. So revisit that if you are still charging quote unquote admin fees, what they actually pay for. And yeah, so just be careful about that. Taylor, anything you want to take there?
Yes, Samantha.
It seemed to be about compensation, about the seller. Answer the question from Samantha about paragraphs 14 and 15, how they're going to work together. That's a really good question.
Yeah, so those are going to
address.
operate exactly how they have been operating.
Right.
Paragraph 14 is the total amount of compensation that the seller is agreeing to compensate their broker. And then down in paragraph 15, that's when they authorize their broker, if they want to, they authorize their broker to share whatever that amount is above with other brokers. I hope that answers the question.
Yeah, and the way I've been kind of explaining it is, even though 15 comes after 14, you really have to look at them together. And I think, Samantha, that's your question. And you're exactly right. It's the total compensation in 14, and then the authority to compensate, will cooperate, obviously, by putting it in the MLS, you're cooperating. The compensation part will be whatever from 14 the seller has agreed to allow you to share. Like Taylor said, that's exactly the way it is today. None of that changes, right? But they have to you have to work together, make sure 14 and 15 work together just the way you do today. So you're 100% right.
Doug Ashley's question was, just because a seller indicates they will consider payments to closing costs, he's referencing that new field on Bright, it does not commit them to actually providing closing help, correct? And he is correct.
Yes.
It is not a binding agreement for that seller to say, yes, I will consider requests, or even if they enter in, I will consider request up to X%. It's not a binding agreement.
Correct. So, we'll see. It's been out for what, 11 days now? So
Yeah.
I'm sure Bright has some experience already. Anecdotally, I've been told that it hasn't been widely used yet. And I guess, Bright's going to be flexible, and they're going to look at this in, 6, 9, 12 months or whatever. And then they're going to see and make a decision about whether that's still a viable option. Again, it's not a mandatory field, but we do I have heard that if it changes, you will be notified of it, just like if there's a change to the sale price. So we will have to know. I mean, you know, buyers ask for concessions all the time, even without this field. So how much this is going to change how you actually have this conversation with buyers is an open question. And if the seller leaves it blank, you know, just do what you would normally do. If the seller says yes, then keep doing what you're going to do. And if the seller says yes with a number on it, that's the maximum, then yeah, that's a conversation you have with the buyer. So, you know, I don't know that that field really should be a focus of a whole lot. I suspect it's going to be blank more often than not. And you're going to have the normal conversation you have with buyers today about seller concessions. The big part comes later about what we're going to do with those concessions, but that's a conversation for later.
Let's see.
So there's a question, Taylor. It says, if we're required to have a buyer representation agreement before showing a property, why do we have a subagent form? I'm not sure what subagent form, you mean subagent compensation in
Yeah,
the brokerage agreement, but we don't have a subagent form per se.
No, correct, we do not.
And so, but the written agreement, so if you are in front of a consumer who is not your client, whether it's a subagent or an unrepresented buyer, you have to give them the agency, Maryland agency disclosure form, understanding whom real estate agents represent. And the settlement agreement requires a written agreement prior to showing a property. We have it from NAR has issued an opinion to us that says, as long as you get, if you are not that person's client, but you are representing the person on the other side, whether as a subagent or a listing agent showing a property to an unrepresented buyer, and you have them sign understanding who real estate agents represent, that satisfies the settlement agreement requirement for a written agreement, because you've notified them that you are working on another person's behalf, even though you are, in fact, showing them that property.
I see one here. This is more of a bright question, but you mentioned there's no time limit for coming soon. I think she means, can you clarify if homes can be shown in coming soon status? So I'm pretty sure Bright's rule is if a listing is listed as coming soon, but that property is made available for showings, then that coming soon status has to be changed to active. But again, these are questions for Bright, because you know it's their rule, so you should reach out to them to clarify that.
So let me address Steve's question about cooperation and compensation. They're completely different things. And part of the frustration over the years for me has been that a lot of people, even our brokers and managers, no offense all, but when I ask the question, what's the difference between cooperation and compensation? I get some blank stares. So let's be real clear. One of the ways in which we need to up our game is to understand the difference between cooperation and compensation. And we redid paragraph 15 to do that. Cooperate means nothing more than sharing information about my property and making it available for showing to your prospective purchasers. That's cooperation. Has nothing to do with compensation. The Code of Ethics makes it very clear, and the offer of cooperation is completely independent of the offer of compensation. So these are two different things. And you can have an offer of cooperation without an offer of compensation to the other brokers by just leaving that blank. If the answer is zero, I am not, or just actually, I guess zero would be the appropriate amount to put in there, but you're still being authorized by the seller to cooperate with other brokers. If you're not, then paragraph 15 is not initialed, and then it's basically an offer, it's an office exclusive at that point. So let's be real clear about paragraph 15. Filling out the offer of cooperation, even if the compensation is zero, they still want it in the MLS. So paragraph 15 still has to be initialed, even if the compensation is zero. So let's keep that very, very clear. So Leonard, let me answer Leonard's question real quick. Isn't cooperative compensation with the settlement agreement completely removed as an option in selling agreements? No, let me just spend a hot second on this. No. The settlement agreement says offers of compensation must be removed and cannot be directly or indirectly tied to the MLS. That's what the settlement agreement says. Maryland law still allows it, and NAR has made it abundantly clear that it is still appropriate. It's within the confines of the settlement agreement and Maryland law to allow cooperative compensation. It just can't be on the MLS. Please understand this. The only question we have to ask ourselves is, if the seller has agreed to this and there will be cooperative compensation, how do we communicate that to the buyer's broker? That's the question you all are going to have to ask and answer on your website, on the sign, by phone. How are you going to communicate that? But it is 100% allowed under the settlement agreement and under Maryland law. And as of today, I know there are questions, about California and NVAR, Northern Virginia Association took it out of their listing agreement. They can make, states and local associations can make policy decisions however they see fit. Maryland Realtors is committed to maintaining this as an option for consumers, and it's well within Maryland law and allowed, 100% allowed by the settlement agreement.
Do we want to move on? We still have a lot of questions, but we got to make sure we get through all the forms.
Yeah, let me see if there's yeah, let's see. Some of these are pretty clean, all offers till settlement. If seller says something in concession, receive an offer for larger concession, you counter offer. So do we still submit the offer? Of course you do. You are required by law to submit all offers, written offers, and counter offers. So yeah, nothing's changing. Let's take a moment here to take a breath. The industry, for the most part, is not changing. Let's be clear. All the rules are still in effect. We still have sub-agency. We will have some extra unrepresented buyers probably. We still have cooperative compensation. It's just not on the MLS. But all the other rules and the seller concessions and how we implement that, yeah, those are be used and the new forms will be used to facilitate that. But you guys are like asking questions about stuff that isn't changing in the law. So let's be real clear. Nothing, even today, if you want to put it in the MLS with zero compensation, that's what you do. That's not changing. It's just not going to go in the MLS. There's no compensation field in the MLS after August 14th. That's the only thing that's changing. So let's not make this even more complicated than it is, okay? And then we will move on, and then if there's questions left over that we don't get to and we have time at the end, we'll come back to these. So go ahead.
Okay. Sounds good. So where we left off, let me hide this. Where we left off was referencing this new listing broker's offer of cooperative compensation form, which we will look at now. So this, the main question coming out of the settlement agreement was, well, if offers of cooperative compensation cannot be made on the MLS, how is that going to be communicated and agreed to between brokers? And that's where this form kind of steps in. So the top here states this document serves as confirmation of the cooperative compensation offered by listing broker to buyer brokers or subagents in relation to the sale of the property noted above. the listing broker shall pay the cooperative compensation to a buyer broker or subagent who completes performance specified herein. And seller acknowledges that the offer of cooperative compensation is fully negotiable and not fixed by law or established by any membership organization with which listing broker is affiliated. So the first section here is basically the first two paragraphs are the same exact paragraphs from is the same information from paragraph 15 in the listing agreement. First section states how much cooperative compensation listing broker is offering to a buyer broker. So you just take whatever that amount is from the listing agreement and put it in here. Second section is how much cooperative compensation is being offered to a subagent, which again, you take that information from the listing agreement and input it in here. Touch on an important paragraph here, paragraph 6. Listing broker and seller may change the offered amount of cooperative compensation, provided the listing broker informs the buyer broker or subagent in writing in advance of the submission of an offer to purchase. The signature section, this is an agreement between brokers. Listing broker is making this offer of cooperative compensation to a buyer broker, for example. So we have the listing broker's signature, the buyer broker's signature, and we also have the seller's signature here. And the forms committee reasoning for adding the seller's signature is just so the seller can confirm that the listing broker is offering the accurate amount of compensation that the seller agreed to authorize in the listing agreement. So like I said, this is an agreement between brokers, so it is not a part of the contract of sale. This is an agreement between brokers, not a part of the contract of sale. Another thing to point out at the top, this form shall not be uploaded to the MLS. It would be the settlement agreement prohibits offers of cooperative compensation from being put on the MLS or anything relating to offers of cooperative compensation on the MLS. So this form cannot be uploaded to the MLS. In practice, how might this, when is this form going to be used? It could be used in a number of ways, but an example could be buyer broker sees a property that their client is interested in. They reach out to the listing broker and ask, what is the offer of cooperative compensation for this property, if anything? Obviously, the listing broker could verbally say what it is, but you want to have something in writing, which is where this form comes in. And the listing broker would then send this form to that buyer's broker saying, offer of cooperative compensation is X amount. And that way the parties have that agreement in writing before the offer is submitted. Chuck, do you have any additions there? Okay. Let's see.
No, I'm good. Go ahead.
So this, I just answered. What is the expectation for how the listing broker's offer of compensation will be shared? It does not go in disclosures, correct? Exactly. So it would be shared in, as the example I gave, listing broker would send this to a buyer's broker. It cannot be put on the MLS. Should there be a separate letter / form from the seller to the buyer broker concerning the compensation? No, this form serves that purpose. Seller has authorized their broker to offer in a certain amount of cooperative compensation, and the listing broker makes that known through this form. There's no reason why the seller would have to reach out to the buyer broker.
Wow, these good questions. Where to start?
Okay, so this question is actually going to be addressed in one of our brand new forms.
Yeah.
when seller offers no cooperative compensation, what MR form is used for a buyer to include in their offer
Oh,
for the
okay.
seller to pay the buyer's broker? We have a brand new form, which we'll touch on in a second.
Or two. It says, or authorized representative, and so when I ask the question, when we say broker or authorized representative, and I say, who's an authorized representative, and I ask brokers, and they look at me funny, I say, it's anybody you authorize. So the answer is, it's entirely up to you, brokers. You obviously, in your employment agreement with your office managers, I am 100% sure you have authorized them to sign documents and actually act on your behalf. They are your authorized representative. There are firms out there, one question, where one can at least question the whether this is good practice or not, but there are certainly brokers out there who have made every agent affiliated with their company an authorized representative. That's entirely within your control. Anybody who you, in writing, authorize to act on your behalf is an authorized representative. So it's up to your company policy as to who you authorize to fill out legal documents on your behalf and to bind you as a company to that document. That's entirely up to you.
Another question here from Sharon: if seller puts 0 in the listing agreement for cooperative compensation, should they put 0 in this form and sign as well? Yes. Whatever amount of cooperative compensation the seller has agreed to, if it's 0, if it's whatever, you would put that in here. That way, buyer broker understands what's being offered. Not only the buyer broker, but the buyer themselves understands, if I submit an offer on this property, how much cooperative compensation is currently being offered.
Right. And there's two questions. Does it get included with the contract? No, this is not in the sales contract. This is this is an agreement between brokers, right? And so if you do any commercial work, and I'm seeing there's quite a few people on this call that I know for a fact do commercial transactions, this is how it works every day, tens of thousands of times a year in the commercial world, where the broker brings the buyer or the tenant, and they come to an agreement, and then the brokers enter into a cooperative compensation agreement. Happens in commercial transactions every day, tens of thousands of times a year. And so that's what this is. It's not part of the sales contract. It's an agreement between the brokers.
Question from Mirna. I understood from Bright the concession amount in that new Bright field could include the payment to cooperative brokers, but the amount could not be only for the broker co-op fee. Well, I think what she's getting at is, yes, a seller concession in that field, again, it's not a binding agreement in that field, but it could include a compensation of a buyer's broker. However, what it can't do is the seller can't say, I am giving you this concession, but you must use it to compensate your broker. At what point would the buyer broker sign this agreement? Ideally, when they receive it from the listing broker. Listing broker sends this over, buyer broker would sign. I don't understand. I wouldn't think of any reason why they would wait to sign this form.
Yeah, there's a question there about referring buyers agents to your website for offers in the agent remarks. I'm going to take the conservative view here and say no, because the settlement agreement says that you cannot use the MLS to directly or indirectly, and that's exactly the wording of the settlement agreement, directly or indirectly in the MLS. So no, I would say the best answer is keep this conversation about compensation 100% out of anything remotely, directly or indirectly connected to the MLS. Not in remarks, not in showing time. Even a reference to check my website for compensation, in the agent remarks, no. I think Bright would flag that, and they can correct me if I'm wrong, but hearing from them over the last few weeks makes me pretty confident in that answer. How does the co-op fee appear on the settlement sheet? Just the way it does today. Nothing changes about as far as what the settlement sheet looks like. I answered that question, Jim Bim, and direct buyer agents to work. Yeah, I'm gonna say no. You can put it on your website, you can put it on a sign, you can put it on a banner hanging out the front window. You just can't use the MLS to facilitate offers of compensation.
Question from Brian: if the seller authorizes the listing broker to offer compensation in a designated amount to the selling broker on this new form, but during a negotiation of an offer, the amount to be paid to the selling broker is changed, does paragraph 7 make the terms of this new form override what was negotiated? Paragraph 7. Well, so the amount, the broker to broker compensation wouldn't be changed in the actual contract, but if the seller wanted to increase their offer of cooperative compensation, they could do so in one of the new forms that we just created.
Let me answer Cleo's question. Clarification on understanding whom agents represent is a contract under the settlement agreement. So Cleo, the settlement agreement says written agreement. It doesn't say the word contract. So I posed to Katie Johnson about 3 or 4 weeks ago, two separate questions. Number one, which I already, and I knew the answer, but it was great to hear from NAR directly, that first of all, sub-agency, because people said, oh, well, sub-agency is going away. They cannot, through a settlement agreement in a private antitrust case, change 400 years of Maryland law. We operate under the common law, so we still have sub-agency. And until the General Assembly of Maryland does away with common law sub-agency, we still have it. So that's the first part. The second part was an unrepresented buyer, because under those circumstances, our members, listing agents in this case, would both be face-to-face with an unrepresented individual, in fact, representing the seller. And how does that comport with the settlement agreement that we have a written agreement in place before we show a house, especially to someone we do not represent? And I told Katie, and she's familiar with our form, and I said, is it your opinion that if we have a prospective buyer and I'm a seller's agent, sign understanding whom real estate agents represent, does that satisfy the settlement agreement's requirement for a written agreement so I can show that property to that buyer? And Katie Johnson said, yes.
Boyd Campbell said, so if the parties of the residential contract of sale choose not to sign the document, is it still valid? So this requires the seller's signature. Again, this is an agreement between brokers, not the parties, but we added in the seller's signature here just so the seller can confirm that, yes, the amount being offered is what they authorized. So you wouldn't need the buyer's signature, but you would need the signature of all the parties listed here. All right, maybe one more, and then we got to move forward. Answer the
There's one question there I just don't understand, so sorry. Yeah, let me just actually, David makes a good point. So there are some, not without naming names, Websites allowing agents to post buyer compensation. Can an outside website, again, take the most conservative approach here for risk management purposes? We're saying no, because these aggregator sites, I'm not really sure how they're going to operate. And I am going to be very wary of you participating in those. So I think if you take information about property, if it's tied somehow back to the MLS, they're going to shut off your IDX feed. And I got to tell you, this is not something we should be playing around with. I am very nervous about this. There are people out there who have this business model where they think they're going to aggregate offers of compensation and be a substitute for the offers that we are now putting in the MLS. I think that's a target on our backs, and the DOJ already wants us. And I don't know why we would do that. We're just asking for trouble. So no, I'm going to recommend highly that you not participate in any of those websites. I just think it's a bad idea.
Okay. We good to move on, or you want to keep going through questions?
Yeah, because I think there's a lot of questions now coming about seller concessions and how that all operates. So that's the next couple of slides. So let's go to those. And I think some of the questions you've asked will be answered in the next few minutes.
Okay, next form is our exclusive buyer tenant residential brokerage agreement. All the changes we have made are in the broker's compensation paragraph. The notice section is changed exactly how the listing agreement notice section was changed, noting that commission rates are negotiable between the buyer and their broker. Also, formally a blank paragraph where the buyer inputs what they are going to compensate their broker has now been removed and replaced with one of these three options. And we state in here, this is new, subject to paragraph 8B, which is below. In the event of a sale or lease, the compensation to be paid by buyer to broker shall be whatever they agree to in this section. Now let's look at 8B. So compensation paid by listing broker or seller. Broker is authorized to receive compensation from the listing broker and or seller. And for property listed in the MLS, how is that going to work? And again, remember, one of our goals was to make this language very easy to understand to a buyer, because the most important thing that came out of the settlement agreement was buyers need to understand how compensation works and what they will be on the hook for. So that was our main focus when we made these changes. So it states compensation may be offered from the listing broker to broker through an offer of cooperative compensation. Broker shall determine the amount of offered compensation from the listing broker prior to submitting an offer to purchase. The amount of compensation received by broker from a listing broker shall be credited against the compensation that the buyer has agreed to pay broker in paragraph 8A, which is that paragraph above. So whatever offer of cooperative compensation the buyer broker gets is going to be credited against the amount the buyer has agreed to pay up here. Except as provided below, if the compensation offered by the listing broker to broker is less than the compensation buyer has agreed to pay above, buyer shall be obligated to pay that difference. If the amount of compensation offered by the listing broker to broker is equal to or greater than the compensation that the buyer agreed to pay in that paragraph above, buyer will not have to pay the compensation specified in that paragraph above. This is a 180 change or 360 change, no, 180 change. Currently, our brokerage agreements state that if the broker were to receive an excess amount of compensation than what the compensation the buyer agreed to pay them, the broker gets to retain that amount. Well, the settlement agreement prohibits that. So now we state in our brokerage agreement, broker is prohibited from receiving any compensation exceeding the compensation amount specified in paragraph 8A, that above paragraph. The amount of any such payment made by listing broker shall be with the seller's and buyer's prior knowledge and consent, and shall in no way affect the obligation of the broker to act on behalf of the buyer in the transaction. I'm pretty sure that language is already in our brokerage agreement. Next paragraph. If the compensation offered by the listing broker to broker is less than the compensation buyer has agreed to pay broker in that above paragraph, and this is a reference to our new form, buyer may include in the offer to purchase a request that the seller compensate broker, which is the buyer's broker, in an amount equal to the difference between the compensation in paragraph 8A and the amount offered by the listing broker, which we will touch on that form right after this. This really didn't change much. Property not listed in the MLS. On property not listed in the MLS, broker shall disclose to the seller at first contact that broker represents buyer and shall provide written confirmation of the disclosure to the seller not later than execution of any purchase or lease agreement. And broker shall make any request for compensation from the seller at first contact. And finally, we added in an initial section, just like the listing agreement, for the buyer to acknowledge that they have read and understand this compensation paragraph. And that's all the changes we have to the buyer agency agreement. All right, let's get to questions.
Yeah, so now that you have the buyer agency agreement signed, now you have to figure out what properties the buyer wants to see, right? So how do you take of all the listings that meet the buyer's requirements? So you have price range, bedrooms, bathrooms, yard, whatever type of property, etc. You have all their requirements, geographic location, all that stuff. Then you go into the MLS and you pick out all the properties that meet their requirements. But for each property, buyer compensation is likely at least to fit into several different categories, because we don't have this blanket unilateral offer of compensation anymore. So the job for the buyer's agent at this point is to review the listings, see if any are offering cooperative compensation, see which ones the seller has authorized a display of whether they're offering or inviting an offer that requests concessions. If so, maybe they've put in a number there. And then you're gonna have to talk to the buyer. Which of these houses are you gonna wanna see? Now, with the seller concessions being unknown, it's gonna be complicated. There is definitely going to be a level of complication here that we don't have today. We readily acknowledge that. And at the end of the day, when it talks about, you know, what is this buyer gonna need to close, what cash to close is the buyer gonna need, it's very likely that they're not gonna know until there's been an offer and counter offer, right? So Taylor, why don't you go to the request for seller compensation and seller contribution addenda. Sure. And talk about those, and then I'll pick up where I left off.
Okay. Okay, so yeah, that referenced new addendum where the buyer can make a request for the seller to compensate their broker is shown here. The buyer request for seller's compensation of buyer's broker addendum. So this is where we have the situation where, let's say buyer has agreed to compensate their broker X amount, and the current offer of cooperative compensation from the listing broker is Y amount, which is lower than X. The buyer here, using this addendum, is requesting the seller to cover that difference, to compensate the buyer's broker in the amount of that difference. And if they do, it would leave the buyer not having to compensate their broker. So first paragraph here is where the parties would input what is currently being offered, the current offer of cooperative compensation. So prior to the execution of this addendum, listing broker has agreed to pay buyer's broker an offer of cooperative compensation in the amount of X. So it could be 0 in here, it could be any amount. Number two, paragraph 2 is where the buyer is making their request. So in addition to any broker-to-broker compensation, the seller hereby agrees to pay buyer's broker the amount of X, which would likely be the request to cover that difference in the offer of cooperative compensation and what the buyer owes their broker. Important paragraphs here. Paragraph 4 states seller hereby authorizes the settlement agent to pay buyer's broker, when they state the amount here, which is the sum of paragraph 1, which is the offer of cooperative compensation, and 2, whatever amount the seller agrees to pay the buyer's broker at settlement from the proceeds of the transaction. Another important paragraph is paragraph 6. Lenders may specify limits on how much a seller or broker can contribute to the buyer to pay for services that are traditionally paid by the buyer. These payments are called IPCs. So payments that the buyer typically pays for, but the seller or the listing broker covers, are considered IPCs. Because offers of cooperative compensation are traditionally paid for by a seller or a seller's broker, it is the intent of the parties that the amount in paragraph 4, which is the total amount, should not be treated as an IPC. And why this is important is because this is a heads up to lenders who read this addendum that whatever amount is agreed to in here, whatever amount is agreed to compensate that buyer's broker, should not be treated as an IPC and therefore will not be counted against that IPC cap. Which is important because a buyer wants as much access to that IPC cap as they can get. So they want to make sure that this amount is not going to count towards that cap. Any add-ons there, Chuck?
No, go do this one and then we'll catch up. There's a lot of questions about, but we need to see how these two forms work together.
You want the seller contribution?
Oh, yeah, and the request for comp. I'm sorry, we did those, yes, right?
Yeah, we've done buyer agency.
Did the comp. Okay, so great. Yeah, no, there's questions though,
Okay.
and how these two work together. So first of all, wanted Taylor to get through that because a lot of questions kind of anticipated that. So this is the hypercritical piece. So being sure that the lender knows, and then ultimately the appraiser post-settlement, but most importantly, the lender has to know which of these are subject to the IPC caps and which are not. So that is really the conversation that you're going to have. Now, how do these all work together? Well, you know, this is, and a lot of questions have been posted about, okay, so suppose I have some cooperative compensation, then the seller either does or doesn't post on Bright that they're willing to accept offers, including seller concessions. And then you have to say, well, what am I going to use the seller concessions for? Right. So that's the workflow. Now, the question is, does the listing broker side of the commission get affected when the buyer broker fee from the listing broker is X, the buyer requests additional amount from the seller? That's really the heart of the matter, right? Because the settlement says, and several questions have implicated this, settlement agreement says very clearly that we are not allowed to accept more in compensation than what we have agreed to in the buyer brokerage agreement. There's been several questions. Well, suppose I cobble together between the offer of cooperative compensation and seller concessions an amount that does exceed what the buyer has agreed to pay me. Can I simply amend the buyer representation agreement and facilitate the acceptance of additional compensation based on the new agreement that I just amended that said X and now it says X plus something? I am not going to, I hate to do this and if those of you who know me know that I usually do like to give straight answers to straight questions. I'm nervous about this. I really am. I am, in my heart, I have an answer that I would love to give you. But because we are so, we're under such scrutiny right now. I mean, they're just waiting for us to mess up, right? The DOJ, let's be clear. I'm gonna take a step back for just a second. Everybody needs to internalize this. If you intend to be in the business for more than 5 years, know that the DOJ will not rest. The Consumer Federation of America will not rest until buyers pay their brokers. That's their end game. And we know that. They've been very clear about that. They do not want sellers or listing brokers to pay buyers' brokers. They want the European model where buyers pay their brokers, full stop. So everything we do to try to, weasel our way around the settlement agreement by saying, oh, well, it says I can't earn more than I've agreed to in the buyer representation agreement. But if I manage to negotiate more, I'll just amend the buyer representation agreement. And the DOJ gets wind of that. All we're doing is asking them to come and drag us all into an additional enforcement action. So I'm just putting that out there to you all to say, I would be extremely careful about doing that. Set your compensation at a level that you are worth. Stick to that and don't get greedy. Don't go into starting this whole thing about, oh, well, I can make even more and cha-ching, and I just do this, and I'm still in agreement with I'm still in compliance with the settlement agreement because I amended the buyer agency agreement to allow me to get more than I did in the first iteration of it. We're just asking for trouble if we go down that path. So I am not answering that question. I would say contact your lawyer. If you have an antitrust lawyer and you can afford $1,200 an hour, ask her. But I'm saying that is just asking for trouble. I really am. And I'm not giving you legal advice. Can't tell you not to do it, but I'm just advising you as your friend that we're just asking for trouble if we start playing games because the DOJ is serious about this and they're relentless and they're not going to stop. So why would we ask for trouble? Why would we put ourselves on the line? I just don't understand it. Let's be careful for at least the next 3 or 4 years until we see how this all plays out. That's my advice.
We have a question from Amy Johnson. The difficulty in asking what the compensation for the buyer agent is, the cooperative compensation, prior to submitting an offer, is that a listing agent may often respond by saying, submit your best offer and the seller will consider. And Chuck and I actually talked about this yesterday. Agent transparency and communication really has to increase following these settlement changes. Obviously in the past, you could see cooperative compensation right on the MLS. Now that is not an option. So yes, you as your buyer's agent, you owe a duty to your buyer to understand how much cooperative compensation is being offered prior to submitting an offer. That way the buyer can make an educated decision. Okay, I know they're offering nothing. I know they're offering X. Yes or no, I do want to submit an offer on this property. And it goes both ways. You all are going to be using these forms, and now you as a seller's agent understand a buyer's agent, per the buyer agent agreement, cannot submit an offer on my property until they know how much cooperative compensation is being offered. So if you're a listing broker or agent who in the past were non-responsive or said something like was said in that question, just know that you're lowering the amount of offers that your property is going to get because you're tying that buyer agent's hands.
Yeah, and the only thing I would add to that, Amy, is if it's in the listing agreement that the seller has already authorized in writing the listing broker to compensate the buyer's broker, that's yes or no and a number. There's the only way you should have that conversation is if the seller, the buyer broker compensation is through seller concessions, right? If it's known, if you call the listing agent and it's in the listing agreement, there's no reason for them to not give you that information. That's already a done deal, right? And so keep in mind that whether the seller is paying it through concessions or the listing broker is paying it through cooperative compensation, the effect on the seller's net is the same, right? I hope everybody understands that, and I know you do. So the only difference in is paperwork at that point, whether the listing broker pays you or the seller pays you, the seller's net doesn't change. So it shouldn't affect the seller's decision. They've already made the decision about whether to compensate you. The question is in cooperative compensation, you know, there's a little less flexibility. So maybe sellers are going to be more interested in using the seller concessions field and entertain offers from the buyers about how much and where that's going to go. We don't know, but those two things, the first question to the buyer, the listing broker, listing agent should be, has the seller agreed to cooperative compensation? And if so, how much? They have to tell you that. So, but Taylor's right. This is going to have to increase the level of communication between buyer's agents and listing agents. There's no question about that.
We got a question, which we kind of addressed earlier, but I think it's important for everybody to know. Should buyer brokerage agreements signed prior to August 15th?
Oh, right. Yeah, thank you.
Which really should be 14th. And not in a pending sale be updated to this version of the buyer brokerage agreement. So if you enter into a buyer brokerage agreement prior to August 14th, we will be providing you with an amendment that your client and you can sign that will make the buyer brokerage agreement compliant with the settlement agreement. So in other words, you wouldn't have to sign a brand new buyer brokerage agreement on August 14th.
Let me address anonymous. Buyers often want to know before showing whether a seller is paying the buyer broker and how much. 100%. And today, yes, they do know. August 15th, they may not. And I think this is a very good question. It was in my introduction, but it deserves to be repeated here. It is very likely that they are not going to know. They're not. And this is the conversation. And that's why you're all here, by the way. And if you remember, the way I opened this was your job for the next 6 weeks is to get agents to understand this. This new reality is we have to have way different conversations with buyers and sellers, specifically as it relates to buyers. There's a lot less certainty now because the answer is they're not going to know necessarily. Now, if it's cooperative compensation and it's communicated to you and you communicate that to the buyer, great. You're going to know what that is. And you're going to explain to the buyer, hey, if it's all of what we agreed to in our buyer representation agreement, you're not going to owe me anything at settlement. Great. If it's a seller concession, the question then is, well, how much is the seller concessions? Are they going to get used to pay me, the buyer's broker, or are they going to be used to pay other closing costs? And if there's a delta between what I'm getting and what you agreed to pay me, that's additional cash to close. The answer is they're not going to know until you're under contract, because you're going to make an offer. If it's going to include seller concessions, where are those concessions going to go? What is the seller going to agree to? And only then is the buyer going to know whether they're going to have to bring extra cash to close to complete your compensation. This is not ideal, folks. Nobody's here pretending that this is great. We're not. But we are saying that your job for the next 6 weeks is to train your agents to have these conversations with buyers and sellers, and specifically on buyers, how this works and how every listing, or if you have 10 listings, 3 could have compensation, 3 could not. Some have buyer concessions or seller concessions that we know about, seller concessions that we're just going to put in the offer and see what the counter offer is. So at the end of the day, we don't know. And that's your job, to prepare your agents to have these conversations with buyers in this new reality with all these new unknowns. That's why we're here. And this is why we've given you this amount of time to get ready. We promise this amount of time because you're gonna take every minute you have to get agents to understand this, to utilize these forms, and to have these conversations with buyers and sellers. It's a lot. We're asking a lot of you, but this is the new reality. So again, we're going to be here. We're going to continue to answer your questions. We're going to continue to provide more collateral. We're going to have additional infographics, additional articles, in addition to the videos we already put out. You can use this. This will be recorded. We're going to have role-playing scenarios. We're going to bring in actual professional actors to help you script your agents on what these conversations look like. But, you know, if it were me, I'd be sitting down with my agents today and say, what are buyers' potential questions going to be? And how do I use these forms to answer their questions? And what is step by step? How do I have the conversation about compensation? How do I curate all these listings that meet their requirements, but the offers of compensation are different in some of them from others? And how does that result in which properties they want to see, which properties they want to make offers on, and which properties they actually end up buying? Okay. No, you will not have these in zip form in advance of the 14th. No, we are providing these to you for these samples now for the purposes of training. And if you don't have them, email me or Taylor. We will get them to you for training purposes. But no, the forms vendors will have them available to you on the effective date.
Sheila asked, can you accept less compensation that is stated in the buyer's agreement? So there's nothing in the settlement agreement that restricts a buyer broker from accepting less compensation that was previously agreed to. But with that being said, the buyer broker should put that in writing that they are agreeing to reduce their compensation for, you know, that specific property that the buyer is submitting an offer on.
I want to address anonymous. Says in the buyer broker agreement, is there a way to memorialize the buyer paying the broker an amount to show properties, and then what compensation would be due if they end up with a successful transaction? Can you get paid for your work leading up to a successful transaction? I have been saying for 20 years now that the brokerage compensation model in real estate is very unique, and that we work on a contingency basis, but so do attorneys. But attorneys also get some fees up front. So even if they're on a contingency basis, that you owe them a retainer or whatever. There is absolutely nothing in the law and nothing in the settlement agreement that prohibits alternative compensation models. It just says blanket unilateral offers of compensation can't be in the MLS. If you want to design in consultation with your attorney an alternative compensation model that compensates you for work, whether or not there's a successful transaction, that is entirely within your purview as a broker. As an owner of a company, you are entitled to investigate any other models of compensation. You are only limited by your imagination and ultimately potentially the law, but there's nothing in the law that says you have to work on 100% contingency fee basis, and that you can spend months with somebody and not earn a dime. So, I would only say to you, call your lawyer. What happens in the future, I would be happy if you would start considering alternative compensation models. Because I feel bad for our members. I know how much they spend, how much time they spend, very often with nothing, literally nothing to show for it. And so, yeah, I would be happy to, if people would start to look into that. My email address is chuck.caskey@mdrealtor.org. So if you need to email me, taylor.kitzmiller@mdrealtor.org. We are happy, if you have follow-up questions, more than happy to answer them.
Chuck, just to chime in real quick, we've got a few people asking if we can get the sample forms again. Yes, I can send this out again to all registrants to make sure that they get the
Okay.
sample forms.
Okay.
Yeah, that would be helpful.
Okay, great.
Um,
Yes,
Chuck-
the webinar, as Kelly mentioned at the beginning, the webinar will be available on our YouTube channel whenever she has an opportunity within the next day or so. Kelly, is that fair to say?
Yes, that's fair.
Okay.
Chuck,
Yeah, go
would
ahead.
you mind if I go to the seller contribution addendum?
Oh, I'm sorry. That's what I thought okay, yes, sorry. I jumped
Yeah.
ahead.
No problem. Okay, this is the last form, revised form. Seller contribution addendum. I'm sure you're all very familiar with this. It's an existing form, but we've added in kind of a disclosure paragraph at the top, and it relates to that discussion we had previously about IPCs. So the disclosure states, the parties shall use this seller contribution addendum to reflect seller's agreement to contribute to buyer's closing costs that are not related to the compensation of buyer's broker. The parties acknowledge that any agreement by the seller or seller's broker to compensate buyer's broker must be made through either one of those two new forms, the buyer request for seller's compensation of buyer's broker addendum, and or the listing broker's offer of cooperative compensation agreement. Again, why we added in this disclosure is to make sure that any agreement to compensate the buyer's broker, whether it's from the seller or the listing broker, is contained in one of those two new forms or both of those two new forms. And that any amount that is entered into the seller contribution addendum does not relate to compensating the buyer's broker. And again, the reason why that's so important is the lender is going to treat the compensation of the buyer's broker not as an IPC. They're not going to count it towards the cap. But if the parties didn't listen to this disclaimer, and let's say they included the compensation of the buyer's broker down here, the lender's not going to know that a certain portion of that amount shouldn't be treated as an IPC, and they're going to treat the whole thing as an IPC. So pretty simple revision there. All right, and
Let's
we can
just take a
still
step
handle.
back. I'm sorry, go ahead.
I was going to say we can still take questions, but I just wanted to say that is all the new / revised forms that we have.
Yeah. And there's a question about training at your office. Yes, please email us. I just gave you our address. Diamond from our office is also available for office visits, and we are very, very happy to come and visit you either at the local board or at your office. Look, I traveled to Frederick County and sat around with 6 people for an hour. I don't really care if it's 2 or 3 people or 300. We don't care. We want to come and we want to be available, and we'll answer your questions because the next few weeks are hypercritical. And I love this statement by Anonymous, who says getting the client into the home of their choice is the imperative, not whether their broker would be paid by another party. One would think that the zero offer of compensation would adversely impact lower income clients. Look, we've been saying this for a long time. When you go to train your agents on these new forms, question is informed consent. The goal, I should say, is informed consent. And informed consent means that you have described effectively the pros and the cons of every decision this client is about to make. Whether it's cooperative compensation or seller concessions, that when before they initial either of those or both of those paragraphs, that we have explained to the sellers, there are pros and cons to every decision they are about to make, including whether you believe or whether you are of the opinion that not offering compensation will decrease the pool of buyers. All of this is going to depend on your market, on the property, on the economic conditions. You know, if I live long enough to see another buyer's market, a lot of this dynamic changes, right? I hope I live to see the next buyer's market, but who knows? Once we get 50,000 more housing units on the market, yeah, maybe we'll come back into balance. But for the time being, there are pluses and minuses to every decision. And so our job is to make those decisions, put them in the hands of the consumers, first of all, not to make these decisions for them, but to make sure that they know what their pluses and minuses. Your net might go up. If you're not going to compensate the buyer's broker, your net's going to go up. But to what extent might you be limiting the pool of prospective buyers for your property? So this is your job, to make sure that we are explaining to consumers all of the ramifications for the decisions they're going to make throughout this process, and to make sure they understand what those are. There is a flow chart. There will be. That's a very good question. We are preparing. I have the draft here, the flow chart and decision trees. We are working on those infographics, and we will have those for you soon. Yes, we promise. Schedule and office. Kelly posted our email addresses. Please let us know. Let's see. People have their hands up. If you have your hand up, okay, 2 of them just went away. But if you do, why don't you try the Q&A first? And again, if we can't get them, we will potentially let you speak, but I'd rather do it through the Q&A. So please post your question. Dave, yes, we will get you. Well, we not necessarily without the highlighted changes. Well, it says Dave, but it's Wanda. I think what we're distributing now are the red line versions, right, Taylor?
Yeah, the highlighted and red line versions.
Clean versions will be available in your forms vendor well in advance. Well, actually, probably a couple days before the effective date. But we're a little bit loath to put out those documents without the changes because we don't want people to use them ahead of time. Is it legal for the listing agent to charge the buyer who has a buyer broker agreement a several $100 transaction fee? Yes. Illegal. You can't, they're not, you don't work, they don't work, you don't work from them, they can't pay you. Any other questions there you want to tackle, Taylor?
I'm looking through right now. A couple questions about when the amendments to the brokerage agreements will be available. They'll likely be available at some point next week. If not, certainly the week after they'll be available.
Oh yeah, I see that. Okay. What about termination language? Let's send that to the legal hotline. I don't think we want to answer that today. Brokerage agreement termination is probably better handled through the legal hotline. So please do that. Amendments to the existing agreements, Taylor, you're working on those. I'm going to say next week.
Mm-hmm.
Okay, next week. Because you have nothing else to do, you know.
Yeah, exactly. Not busy at all.
Cleo, what should you do if the listing agent broker does not inform you or does not send the buyer agency comp form to you before you want to submit an offer? No, you fill it out. So if you call, if you can't identify it on the website, or you call the listing agent, are you offering cooperative compensation, through the seller for the listing agreement? Yes or no? If no, we will be sending a request if it's blank, if the seller concession field is blank. No, that's a conversation you have with the buyer. Do you want to ask for concessions? And if so, do you want them to closing costs or for buyer broker compensation? And then you include one or both or neither of the addenda in the offer, because that's the buyer's decision. At the end of the day, not the seller's. That's the buyer's decision about what to include in the offer as far as seller concessions go. Just the way it is today, right? Even if there's nothing but buyers put requests for seller concessions in the offer all the time today. That's not going to change. I'm not going to talk about admin fees. I know it's a hot topic. That's a separate conversation. And I think we wrote an article a few years ago on possible RESPA violations of admin fees. We're not going to talk about that today, but I'll dig out that article and recirculate that to you all. It's been a problem for a while. So I'm loath to answer that question today as we're sitting here. Yeah, technology fee again. I'm not saying it doesn't exist. I'm just saying that there's problems with it. My understanding after taking Bright's class, offers of compensation can be put into the new concessions field and then in the final concessions field as to what was eventually received. Yeah, if they're coming directly from the seller, yes, that's different than the cooperative compensation from the listing broker to the buyer's broker. But yes, they're not mutually exclusive.
When do current listing
David,
agreements?
flat fee commission. Thank you. Dave Cummings answered your question. It's compensation. It's all compensation. And we run into trouble if we start calling it anything else but compensation.
When do current listing agreements need to be redone to comply with new forms? Again, we will provide you with an amendment that you and your client can sign prior to August 14th. And that amendment will become effective on August 14th. So you would not have to sign a brand new listing agreement.
Just the amendment, right?
Amendment, right.
Right, and starting on the 15th, the new brokerage agreements. Posting compensation on your website. Well, compensation fee. Oh, what you charge. Look, yeah, people do it all the time. Brokerages all the time say, yeah, list for me the flat fee brokerage, the brokerage out there advertising their pricing. Look, that's what the DOJ wants. They want us to compete, and we do. You guys know that. So yeah, if you want to attract business, now, what the DOJ would love to see is a race to the bottom. And I'm not here to say, let me make this very clear. I am not here simply, nor is Maryland Realtors here to protect the status quo. We are not. We are here to promote compensation, to promote competition, because you are competitors. You're all on this call, but you are competing against one another. If you want to compete on price, do it. That's what negotiable means. Negotiable means in the antitrust world that competitors do not get together and collectively agree to charge a certain amount and no less. Now, I wish I could sit here and say we've never done that, but the fact of the matter is we have, and we've done it right here in Maryland. And so, we are not completely blameless here. We have fixed prices, and this industry has fixed prices in the past. That's why the DOJ is coming after us. So if you want to compete on price, you should. DOJ would love that. Wow, Maria, an article written by Al Monschauer. To 8B or not to 8B. I gotta find that. Please email that to me. I'm not familiar with that, but I would love to read it. I miss Al almost every day.
Chuck, can I chime in here? There was
Yes, please.
an anonymous attendee who said, how can other brokers join this forum? Tell them. We are actively adding emails from brokers and office managers. If you do not update your email to your local board or association, then we don't get that information either. So if there is anybody that you know who's not on this call today, that should be, have them email us so that we can add them to our list.
Yeah. Let me address anonymous about, is it unethical for us not to tell sellers what the possible negative consequences of offering or not offering compensation to buyer's broker? We are required, I'm not gonna answer that question directly, unfortunately, because that's a legal opinion, or a conclusion, I should say. In any situation like that, I would remind us all that something that probably should not have to be stated, but we are required by our fiduciary duty and the Realtor Code of Ethics to act in our client's best interest. And so when you get hired and your agents have to have this conversation, I would just go back to my conversation about informed consent. You are required to give them the benefit of all of your expertise, and whether there are negative consequences and positive consequences, to the best of your ability, you should be doing that. That is the definition of informed consent, and fulfills your ethical obligation to act in your client's best interest. And ultimately, though, the decision is theirs. So I'm going to leave it at that because I think it's pretty self-evident. If a buyer broker client, if a buyer broker client makes a complaint against the buyer broker, if the client makes a complaint against the broker for not being able to secure property in their price point based on low seller offered compensation, nothing. Look, it's a great question. It turns it on its head though, right? Because you have already had this conversation. I think that this question illustrates my earlier point about your training of your agents about the conversation very early on with buyer clients, right? So here's the list of properties that meet your criteria. And here for each of these properties is the offer of compensation or the seller's or the ability of us to ask the seller for concessions, some of which can be used to pay my compensation as the buyer's broker. At the end of the day, if it's an unknown and if we cannot secure the full amount of compensation you've agreed to pay me from the seller or listing broker, you're going to owe me the difference. And that means you're going to have the additional cash to close. You understand that, right? By signing the buyer agency agreement, they are telling you they understand that. So when you have that conversation later on about, oh, you didn't get that property because you don't have the cash to close because you were going to have to pay me compensation, you have it in writing that you explained it all to them. There's no more liability on your part. You've done your part by explaining all of this very early on. When you get that buyer agency agreement signed, you have run through all of these potential scenarios, including the fact that some properties might be out of reach for you as a buyer because you don't have the cash to pay my commission if we don't get a certain amount of money of compensation from the listing broker or the seller. So there should never be a complaint because you have explained this over and over and over again, and they have told you you understand it. So if you do your work well ahead of time, that's what risk management is. And you guys, brokers and managers, this is your job. I'll say it again. That's why we're doing this. We're giving you 6 or 7 weeks to get ready for this. Train your agents, train them, get their thinking. And I'll tell you, young people are going to get this. Your new agents, they're going to say, oh, what's the big deal? It's us old people who don't like change. We're going to be the problem because we're going to just lament, it was so much easier. Tough. Get over it and learn this is the new world we are in. And it's your job to make sure the old people and the new people understand it and give them the tools to live in this new world, because it's here and there's no going back. That's why we didn't even talk about the settlement today, because that's old news. We're looking forward.
I saw some questions, not really questions, but suggestions for slight revisions to some of these forms. These versions of the forms are what's going to be published in August. We might make a couple tweaks based on, some changes that could happen, but any suggestions like those, we will take them in and they will be provided for the forms committee for the next year's forms committee, which starts in October to consider. But these forms, as of right now, are what's going to be published in August.
Yeah. And Nancy makes an interesting point that we should be prepared, unfortunately, in my humble opinion, for some level of increase in unrepresented buyers. And I think that's going to be an unfortunate consequence of this. I think the Consumer Federation of America believes, I guess I want to believe in their heart, they think they're acting in the best interest of consumers. I'm not so sure that's true. I'm kind of sad about this because I really do think while we may not be blameless in this, because we have fixed prices and we have steered. I mean, I'm going to be really honest with you. Anybody who says that in the past we have not steered clients to properties based on the amount of compensation that I would be receiving as the buyer's agent, they're just that's a lie, because I know we have. I've witnessed it. I've been a party to it. I've seen it happen, and I know we have done it. So first of all, let's start from the proposition that we are not entirely blameless as an industry for what we are confronting now. I wish I could say that we're just victims. We're not. We engaged in some of this bad behavior and we are paying the cost of that. And there are consequences to that. That said, what we are going to be doing next is demonstrating to consumers the value of using a realtor, even if they have to end up paying for that. And it's not just value, it's your worth. So part of what I think you should consider in terms of training for the agents, the buyer's agents specifically, is here's what I earn. This is my living. I support my family doing this. This is my job, just like you have a job and you get a salary and you support your family, so do I. And this is what I do to earn, and I'm worth every penny of what I earn. And even if you have to pay it, I am worth it. And we have to demonstrate to consumers that we do earn our commissions, especially on the buyer side, when we've been able to skate pretty much by not having to demonstrate our worth and our value because the listing broker paid us. But now that's all out the window. So we have to learn this whole new script, this whole new way of selling ourselves, if you will, of demonstrating that we earn that money and we are worth it. We are in the midst of planning a very, very robust consumer campaign that's going to educate the consumers about the value and the worth of using a realtor in the transaction. So yeah, we might see a bump in the number of unrepresented buyers, but eventually buyers are going to come to understand that it's worth it to have professional representation in this transaction. We're just going to have to adjust to the new reality that on occasion they're going to have to, pay us. There really isn't another industry on the planet that I know of where I hire somebody for professional advice and assistance and don't pay them. So I'm confident that over time this will be not as big a deal as we think it might be. I don't think it's going to be the end of the world, but we have to be prepared for it. And we will be helping with that by a consumer campaign to demonstrate the value and the worth of realtors in the transaction.
Seeing a lot of just comments, not really questions.
Yeah, anonymous, they've always paid for it. Look, this is, yeah, it's been baked in the price, and that's my problem with the lenders too. Why are the lenders folding it into the loan? They already do. Lenders finance commissions today. And appraisers know it because they take commissions and take other concessions off when they do comps. But lenders know it. As long as it appraises, they don't care. They're financing commissions today. So why is all this angst about, oh, brokers, lenders aren't going to finance commissions? Well, they do it now. So I don't disagree. We are really it's going to be a transition, folks. There's no way around that. But I really think job is really to start training people again. New construction steers, well, yeah, one could argue all, but yeah, can first-time buyers not pay our commissions? Look, sometimes they can, sometimes they can't. Now, I was in a meeting today and an agent said, look, I was just with some buyers, young buyers, and it was like, oh, I really want this house, and yeah, it's a little above my price range, and oh, I don't have the cash to close. And 3 days later, they said, oh, I found the cash. Magically cash appears. So yeah, this whole thing about, I don't know how it's going to play out, but buyers will adjust and we will adjust. So yeah, let's just keep our wits about us, be flexible, and call us, please. Let us know. I have a couple things about, when can we come out? Just let us know. Anytime we can come out and help train, we will be there. I promise. Well, look, Jim says, he took offense, and I didn't mean you, but we as an industry, you can take offense. I apologize if you're offended by it. It's just true. Prince George's County was subject of a Department of Justice price fixing in 1970, not that long ago. So, and I was a subject of steering personally. Happened to me 25 years ago. I wasn't even in real estate. And so I don't mean to offend anybody by saying specifically you or you did it. I was speaking broadly as an industry, saying that there is in fact a reason why the Department of Justice is coming after us. That's all. That was my point, and I stand by it. VA. Do you want to talk about VA a little bit there, Taylor?
Yeah, what was the question?
What are they going to do? Well, what
VA.
have they done, and what do we think is going to happen next?
Right, so temporarily, the VA has lifted their restriction on not allowing buyers to compensate, VA buyers to compensate their broker. So currently, VA buyers, in that sense, compensating their broker, are treated as every other type of buyer. We don't know when the VA, they've said they will address, they said it's a temporary measure and they'll review it at a later time. We don't know exactly when that will be. But yeah, for the time being, VA buyers, when it comes to compensating brokers, are allowed to and are treated just as any other buyer.
And there's one last, well, I'll stay on. Taylor and I will stay on. Let's see. Yeah, we still got a lot of people, folks. We're gonna stay as long as you are staying here. We will too. Okay. For buyers who don't want to use an agent, go directly to the listing agent. We talked about this before.
Yeah.
They want to write an offer on the listing. Are they an unrepresented buyer? Yes, they are.
Yes.
The epitome of an unrepresented buyer. And as you know from your Brad class, on behalf, first of all, the first thing you do, of course, You have them sign understanding whom real estate agents represent, and they acknowledge, whether by signing it or having you attest that you give it to them or that they refuse to sign it, but you gave it to them anyway, that they understand that you are the seller's agent. And on their behalf, as you all know, you're gonna have to retrain your agents if you don't, or they're not aware of this, or they haven't done it in a while. On the behalf of an unrepresented buyer, you may perform what the Brokers Act defines as ministerial acts. The ministerial acts are very, very simple. You can fill out the blanks of a contract, submit it to the seller, but you cannot, and this is really important, if we're gonna see an uptick in unrepresented buyers, I would recommend spending a little bit of an additional training time talking about ministerial acts and not stepping over that line into illegal dual agency. Because if we go out of that box and we start helping this unrepresented buyer by giving them negotiating advice, or, should I get, because we know they do that, right? They're like, oh, help me write an offer. Okay, here's a blank. What do you want to put in it? Well, I don't know. Or they take less than the listing price. And what about this contingency? Should I get a financing contingency? How about a home inspection? It's a trap. And these buyers are laying a trap for us. They want us to represent them, and that's illegal in Maryland. And so I think we need to pay additional attention to the fact that if we do see this influx of unrepresented buyers, they're going to try to trap us into illegal dual representation, dual agency. And so be hyper, aware of that potential, and extra training time on how to deal with unrepresented buyers, get the agency disclosure form signed, and stick to those ministerial acts. Do not step over that line, because that's going to get us into deep, deep trouble. So be very vigilant about that, please. Anything else?
Can listing agent charge unrepresented buyers for helping with contracts? The answer to that would be no. They can't.
No.
Unrepresented buyer. No, you cannot charge an unrepresented buyer who you do not represent for
Again,
helping with the
that's
contract.
illegal dual agency. Now, what we teach is, if this buyer, in the course of hearing from the listing agent, I can't help you with that. I can't do that. You have to tell me what to put in this blank, and I'll present it to the seller and see what they says. If the buyer gets frustrated with that, and the way I always taught this was, hey, look, buyers, if you want representation, my colleague down the hall is a fantastic buyer agent, or my team has the buyer agent. I am happy to sit you down with that person, and engage in real legal dual agency under Maryland, where two agents within the same brokerage, one represents the buyer and one represents the seller. But no, you cannot charge except for brokerage services, and that has to be commensurate with a brokerage agreement. And again, the laws of dual agency apply to that. So please don't make this more complicated. And there's some traps there. So please, please, please. Do I see Maryland going to single agent dual agency like Virginia? No, the answer is no, David, and here's the reason. We're so tortuous to get to where we are today that we will not ever, because that's the common law, and we're past that. And actually, it's not really single agent dual agency, because at the end of the day, under the common law, and in New Jersey as well, if a single agent attempts to quote unquote represent both parties, they represent neither. Under the common law, the fiduciary duties basically cancel out, and you become a facilitator, right? And so, or transactional broker. And I will tell you that we are in the process, and I'm glad you reminded me, because I kind of forget that sometimes, that we are in the process of revisiting the concept of bringing to Maryland this notion of transactional brokerage, where in fact, we are nobody's agent Because personally, I don't think agency belongs in real estate. We're professionals, we're facilitators, and I think that should be a legally recognized, at least option for quote unquote representation, where I'm neither party's agent, but I am bringing a willing buyer and a willing seller together, and I am facilitating that transaction. Whether you call it transactional brokerage or facilitation, I think that should be an option in Maryland that we don't currently have, but we are looking at that as a public policy initiative for next year. So I personally would like to see it, and yeah, we'll see where it goes. We have a kind of paternalistic bent here in our General Assembly. Consumers need all this kind of protection. Part of me says, look, and I'm not a big libertarian by any means, but if two adults want to just hire me to help them settle a real estate transaction, I can't do that in Maryland today. I don't understand why. Yeah, thanks, Boyd. I'm doing it for you.
Yeah, with an exclamation point, he says, yeah.
As a listing agent, we get a bunch of unrepresented buyers who want to see my listing, strangers to us. Typically for safe practices, we'd ask them to see a pre-approval license. Yeah, absolutely. The same, nothing has changed.
Yeah, the same way.
And we're looking into, yes, do everything you do. Nothing's changed. And if the buyer refuses your recommendation to use an agent, if they get disgruntled enough, they're going to walk. That means they're not serious. So you haven't lost anything. And if they do know what they want, and look, you guys know this as well as anybody, there's some pretty sophisticated buyers out there. They know exactly what they want. And maybe they don't actually need representation. Maybe they know how much this property is worth, what they're going to offer, whether they want a contingency, how much cash they have. If they're pre-approved, they're bringing you, and some of that can work extremely well. Some of it can't. If an unserious buyer is taking up that much of your agent's time, you're gonna have to tell them, look, I got actual work to do, and I have somebody who actually is paying me. So you know what? We're done here. So none of this has changed, right? A lot of this is just an extension of what we already do and what we already know. I truly believe that.
I just wanted to note one thing. I wasn't sure if we mentioned it earlier. Next week, at some point, all the educational versions of the forms, along with educational videos, written material, is going to be released to all members, not just brokers and managers. It's going to be released to everybody at some point next week, likely Monday. So next week, everybody, through all of our members throughout Maryland, should have access to these forms.
So I'm going to go back to the beginning. Amy asked, excuse me, if cooperative compensation can be shared on social media. I don't see why not. Taylor, you agree?
Yeah, no, I agree. There's nothing prohibiting that. Really, the only prohibitions was it can't be on the MLS, and it can't be on something that's getting an IDX feed from the MLS, like Showing Time.
Right. No time limit on coming soon. If you have a question on coming soon, that's a question for Bright to answer. I cannot clarify coming soon status. That's a Bright MLS question. Unfortunately, I don't like doing that. Paragraph 14, broker compensation. Agent should just put in the amount being paid to the listing broker and not include the total amount as we have done in the past. Is that right? That doesn't sound right.
No, that's not right.
No, Linda, call us. Yeah, I don't think that's right. Call us. We'll run that through you. Paragraph 14, total compensation to the listing broker, and 15 is sharing of compensation. Yes. Like I said at the beginning, and Taylor reiterated as well, 14 and 15 have to work together. And sometimes I think 15 has to be answered first, right? So even though 15 comes after 14, you know what I'm saying? You have to have the conversation about cooperation and cooperating compensation before you can really fill in the total compensation amount. Does that make sense?
Yeah.
Yeah. So even though 15 comes after 14, they really have to be done together. I think I answered on sub-agency, and in fact, that the understanding whom agents represent is enough. No, we did that one. Good day. Great. Does the listing agreement address assisting an unrepresented buyer? No, because
No, it's not.
agency law does. Retainer fee. Yeah, look, Billy, if you want to have an alternative model and you want to charge a retainer fee, there is nothing in the law preventing you from doing that. Check with your lawyer first, please. Check with your lawyer. Look, admin fees, RESPA compliance, talk to an attorney who's familiar with RESPA. I'm not going to answer any more questions on admin fees. You all need to check your, check with your lawyer who's familiar with RESPA, please. DOJ after concessions in Bright. At this point, no, because the settlement agreement specifically says it's okay for even brokers to continue to compensate other brokers. It just can't be in the MLS. So let's be real clear about that. The seller signing the agreement, listing agreement regarding seller concession. Seller says no, then the buyer needs it, and the seller changes their mind. Do we need a new listing agreement? No, you just revise, just a very small amendment to the listing agreement. You don't need to enter into a whole new one. But as brokers, your lawyer, work with your lawyer, just the way they would change the sale price, right? There's just a very, if you go to it's no different than the property sits for a couple of weeks and the seller says, well, maybe I overpriced it. Let's reduce the price. The exact same, the same process for changing the seller concession field that you would do to change the sale price. Exactly the same process. Would you agree, Taylor?
Yeah, exactly the same. And I saw another one, kind of similar to the question we had before about where you can publish cooperative compensation. Question was, if I'm creating a flyer for a property, can I state the compensation amount on there? The answer is yes. It's outside the MLS. That is allowed.
So if you asked a question an hour ago and we didn't get to it and you still are dying for an answer, just throw another one in the Q&A, please. I see,
Somebody said, when did you say the transactional broker will be introduced to Maryland? That's just a possibility that we might try to get past. So we are not sure.
It's in Chuck's head right now. Other states have it. Our advocacy team is working on it. We have to take it to our public policy committee. Then we have to get it passed by the General Assembly. We have to convince them it's a great idea. They probably won't agree. It could be 2 or 3 years from now. Who knows? We have to take the long view on some of this stuff. But yeah, it's just right now, it's just something that we're looking into. Yeah. Is there an embargo on sharing the videos? No. The videos are out, aren't they? Didn't we publish the videos?
The videos were, they were sent to, on the email list. We sent out all the video links. They're technically unlisted on our YouTube page, but they would be made public on Monday.
Okay, great. Okay, Amy, hopefully that answered your question. Can I say in remarks, please call listing agents with any questions? Or would that be insinuating? That's again a question for Bright.
Yeah.
I want to answer it and say yes, but at the end of the day, anything that goes into Bright is going to be up to them.
Right.
You know, it's crazy what y'all are coming up with. I love it. You know, I saw one on somebody on Facebook the other day that said, oh, I'm a real big fan of 3% milk. You know, look, it's funny. I got a laugh out of it. But again, you know, what we're telling you is, be careful, because they're coming after us and they're not gonna go away. And no matter what happens, these are career DOJ people. I had somebody asked me the other day, well, you know, after the next election, is everything going to be different? No, no matter what happens. These are career prosecutors. They are experts in antitrust law, and we are in their sights. And the Consumer Federation of America thinks that we are ripping people off, whether we agree with it or not. That's what they think. And so we are dealing with this reality. So let's just not give them additional opportunities to keep us in their sights. These are the new rules, right? Let's do what we need to do to adapt to this new reality, and don't keep kicking this hornet's nest. It's not going to end well for us, I promise you, because they have unlimited resources and we don't. You know, and that's why NAR settled. You know, they had a binary choice: go bankrupt, appeal, go bankrupt, or settle. So here we are. Social media intertwines with the one-click rule. You're posting an IDX link. You should to protect yourself. Ooh. I'm not sure I know the answer to that off the top of my head.
Yeah, so if you're posting a link which takes you to a website that does get an IDX feed from Bright, that's a tough question.
Yeah, I don't know. Let's keep that under advisement. We will post something as soon as we have a better answer for that. We may have to coordinate with Bright to get an answer to that.
Somebody said I joined late, so I just want to make sure I got it right. If cooperating brokers can compensate buyer agents, then for every listing, we would need to call the other broker and ask if they are offering compensation, or how would we know if the other broker is offering compensation? So
that's the conversation. Go ahead. I'm sorry. Go ahead.
Yeah, I mean, it may come down to that where you do have to call the other broker. But there's other possibilities where, like we said, you can advertise on social media, on your flyer. So you might be able to get that information somewhere else.
On the website for that property?
On the website for the property. However, you know that information, but you still want to make sure you have that in writing, that listing brokers offer of cooperative compensation in writing. So yes, at some point, you're going to have to contact that agent and request that form.
Marty, buyer agency was the bane of industry. You know, Marty, I don't know that it was buyer agency, because I think buyers always deserved representation. I think the bane of real estate was not biting the bullet. And I know this is controversial, but I love saying it. When we made the decision to give buyers representation, but still allow sellers or listing brokers to pay for buyers brokers, that's what created the confusion 20 years ago, 20 some years ago now. 25, actually, 25 years ago. That's not just buyer agency, but because of the disconnect between representation and compensation, that's what got us here. So I don't know that it was just buyer agency. Buyers really deserved representation. It's the biggest decision, the biggest commitment most people make in their entire lives. So of course they deserve representation. So yeah. Showing time is not a good place.
Yeah. Showing time is not a good place to display compensation.
Not.
You cannot
they
do
will
that.
not take it. Yeah. If you're going to share, let me just, Edward just asked Marie if to share scripts. Look, and I didn't see Marie offering, oh, there. Oh, the article was written. Is that what Maria is talking about? A script? 8B or
No.
not 8B to 8B? I'm not sure what that means. But anyway, let's be careful about what we're sharing. Again, it goes back to collusion. I believe, look, wait for us. We will be providing material, collateral for you to help your agents explain your worth as agents, buyers and sellers agents. I'm a little bit nervous about sharing that between competitors because it just makes me nervous. That's what got us into this mess. So let's just work on your own. Your agents know this stuff, right? I mean, they've had the experience, and you guys too. Most of you have bought and sold, and many of you still are. So just keep this between us right now. I'm a little bit leery about competitors sharing information and scripts. And that's one of the things that got NAR into trouble, by the way, that their training materials were used against them at the trial. So we have to be very careful even about what we put out as the state association as far as training materials go. So yeah, let's develop our own independently. Let's not share too much between competitors. Unfortunately, that's going to be potential fodder for the next enforcement action. What else? Okay, thanks, Ed. Just to be sure, as a listing agent, I can get paid as a sub-agent if I'm helping the buyer as well, as long as the compensation comes from the seller, correct? And I have whom I represent signed by both parties. So this is an interesting conversation, and Taylor and I have talked about this, in the statewide forums committee will be looking at this. I'm going to reframe that question, right? So we've seen examples. Actually, Taylor, why don't you talk about this? And we're talking about, is that additional compensation for an unrepresented buyer? You want to talk about that a little bit?
Yeah, we've seen some
Yeah.
associations, whether they had it before or they just revised it for their listing agreements, where they've added in a new spot where if that listing agent is dealing with an unrepresented buyer, the seller agrees to pay that listing agent or listing broker in additional amounts because they're having to do that extra work. Now it's ministerial acts, but they're having to do that extra work when they're working with an underrepresented buyer. So that is something that the statewide forums committee will consider for at the start of their next committee year in October.
Yeah, so I'd be careful about that. But again, remember, the brokerage agreement is a recommended form, right? It's not a required form. You can make your own. You can use ours as a template. We absolve you of just take our, if you want to change it, just take our copyright off, make it your own. Check with your lawyer. But off the top of my head, I don't see any legal impediment to charging a little more from the seller if I end up with an unrepresented buyer. But again, that's just Chuck. I am not giving you legal advice. We are not your lawyers, right? So before you do anything regarding compensation, check with your attorney. And if you want to put that in your listing agreement, do not say Maryland Realtor said it was okay, because I will have this as evidence that I am not saying that. We are not saying that. We are saying that you should check with your counsel if you want to add additional compensation for the listing broker from the seller. If they're dealing with an unrepresented buyer, you must check with your attorney before you put that in your listing agreement. Oh, 8B, as section 8B, of course. Sorry, I'm stupid. Yes, RESPA 8B, yes. Okay, great. Yes, I will look that. I think I'm getting close to remembering. I think we did that. I'm not sure that was Al. I think we did an article a while ago on admin fees and RESPA section 8B. Now I'm gonna go dig in my archives. I'm pretty sure I can find that. Thank you, Maria. I appreciate that.
The question here, if seller has a signed listing agreement with the listing broker and the listing broker is not sharing the commission with buyer agent, can the buyer's agent ask in the contract for the seller to pay the buyer's agent? Let's say if the buyer's agent works with a buyer who cannot pay the commission, can the buyer's agent ask the seller as part of the contract to get paid by the seller? That is exactly what our brand new addendum to the contract accomplishes. And it's not the buyer agent asking for it. It is the seller asking it is the buyer asking the seller to compensate the buyer's broker.
Right. So let me address Sharon's question. We talked about this and so if you don't have the form in front of you, I get it, but go back later and review this. But when you go to fill out the listing agreement, this goes back to paragraphs 14 and 15, right? And so you have total compensation in 14, and then you have cooperating compensation in 15. Now, again, as I said earlier, you almost have to have the conversation with 15 first, right? But suppose, and this is happening, and this concerns me greatly. So Sharon, thank you for bringing this up because I have a real concern about this. Today, the practice is there is total compensation. And some amount of that is being shared with the buyer's broker. So the commission paid, net commission to the listing broker is total compensation minus cooperating compensation, right? What if the number in paragraph 14 is a number that would traditionally represent an amount to be split with the buyer's broker, cooperating broker, but the amount in number 50 in paragraph 15 is 0. So that means the listing broker is earning the full amount of compensation, even if that amount would have historically been split with the buyer's broker. But now the listing broker is retaining all of that. Sharon, confirm quickly in the Q&A that I restated that to your satisfaction. That's the question that I've been asked several times now. I can tell you anecdotally that's happening. And people have called me and said they were at settlement and the buyer's agent and the listing agent and the buyer, excuse me, got the settlement statement, and the buyer was well, there was no compensation coming from the listing broker, so the buyer was required to pay the buyer's agent, buyer's broker's compensation. And then they looked at the settlement statement, and the seller, in fact, just paid the listing broker an amount that historically would have been split with the buyer's broker, but in this case was not. And the buyer's agent was kind of flabbergasted by it, and so was the buyer, because the listing agent or the buyer's agent was like, well, normally it's, whatever it is, split between the two brokers. And here this listing broker was getting paid, I'm just going to say twice, what the buyer's broker got paid. I hope everybody followed that, but that's happening. It has happened and it is happening. And all I'm going to say about that is you can charge whatever you can get, right? If you want to charge a 30% commission, charge 30%. If you can get sellers to pay you that, good on you. And that may result in some temporary windfalls, to listing brokers in this circumstance before sellers kind of catch on to it. But I can tell you, if the whole point of this is competition and sellers start actually price shopping and going to 3 or 4 listing brokers before they decide who to list with, and they start understanding the amount of compensation net to the listing broker, and they catch on to the fact that, well, if I'm gonna pay you X and you're not gonna pay Y to the buyer's broker, you're just gonna keep all of X, then maybe I'm gonna figure that out and go someplace else. And I hope that made sense, because it is happening, and I'm concerned about it on the one hand. On the other hand, consumers, they have to figure this out for themselves. And when we talk about commissions being negotiable, this is what we mean. We mean that competing brokers are gonna have to compete, and one of the things they're gonna have to compete on at some point is price. Once consumers get sophisticated enough to do that in the real estate transaction, which they do already. I mean, who doesn't? I buy a TV, I'm gonna shop Best Buy and Costco, and I'm gonna pay the least amount for that TV that I can possibly get, right? And so consumers are gonna start doing that with real estate brokers. They are. Let's be honest. And that's what the DOJ wants, and that's the nature of competition. And so, yeah, if there's no, look, the listing broker can charge what they want. Are they entitled to the full compensation? If the seller agreed to pay the full compensation to the seller, the answer is yes, they are, because the seller agreed to pay it. And if the seller agrees to pay listing broker compensation, without sharing it with the buyer's broker, okay. I think it's temporary. But good on them for now. But then, what does that do to your reputation once sellers start talking to each other, and now they know, what does that do to your reputation? That's what I would want to know, because I, put those reviews out there. I just found out that I overpaid my broker. What's that going to look like on social media? What else? 142 of you still out there. Thank you all for hanging in there. 2.5 hours later. You guys are great. Got a lot of stamina. Oh. How often are sellers not paying attention to the buyer comp plan and thinking their commission is being split? Well, you would know better than we do. I don't know.
Right. And that's why the listing agreement should be explained in detail to sellers, so they have a full understanding of what compensation looks like.
And look, anonymous, yeah, I'm sorry, go ahead.
No, I was gonna say, does that mean that agents are doing that? No, it probably, some agents might not be, but they should be doing that.
Yeah, and look, I do, if I had to say it over, I'd probably say it differently. If you do that and you have done the work of both sides, or the buyer's agent hasn't done the work, and you're entitled to your compensation, great. All I'm saying is, it has to be transparent. And I should have just shut up at saying your compensation has to be transparent, fully explained to your client. And I should have just said that and nothing more. So I apologize. I kind of got on my soapbox there. And it does go back to training. Yes, thank you, Marie. You're 100% right. Sharon, I was asking based on unrepresented buyer paying 0 and the listing broker gets to retain the total. Yeah, well, that I think I answered that. Yes.
Yeah.
Yeah. So I think you're right.
I'm not seeing any new questions rolling in.
To make it easier, let's Melanie, to make it easier, more streamlined for listing agents, are they able to send the buyer compensation form that has been completed? Well, listing agents can't have can't communicate with the buyer except through their agent, so not really sure I understand that. As a listing agent, I can get paid as a sub-agent. No. If I'm helping the buyer, no,
No, you
No.
cannot.
no. I think we answered that question, didn't we?
Yeah,
Okay. Not seeing anything new come in. At what point, I'm just gonna go back an hour or so, what point do we compromise our fiduciary duty to our client as we petition the other agent repeatedly to confirm the offer of compensation? During the exchange, another offer comes in and asks for compensation. I'm not sure that's in competition, Boyd. I think if you're still on, no, I don't see that as being an impediment and certainly not a violation of a fiduciary duty, because they're going through the same thing, right? We're all gonna be on a pretty much level playing field at that point. So, yeah, I'm not necessarily think that's gonna be a problem. Yeah, look, Jim says, more uncertainty. Yeah, there's no questions. There's no question about that. These are unknowns, and this is a lot of work we have ahead of us to get ready for these changes. And unfortunately, it's gonna fall on us and you to make sure that people are trained. I think today gave us a pretty good idea of what kind of questions are out there, and these aren't with a couple of exceptions, right, Taylor? These are the questions we're getting wherever we
Yeah.
go. So
Mhm.
that's actually a good thing because I think at least we're getting a good FAQ on what the questions are at the top of people's minds.
Right.
Yeah, there's a really good question, and then we'll wrap it up. Compensations on sites, the IDX feed, our understanding at this point, and actually, I'm pretty sure we're gonna have to get a definitive answer. Let me put it this way. I don't want to get on record. We need to clarify the relationship of the agent property-specific website, whether putting the offer of compensation on your agent-specific, property-specific website, even if the broker gets the IDX feed, is that the indirect sharing of the compensation under the settlement agreement? We're gonna have to get additional clarification on that, and within the next week or so, we will have that. I don't want to answer that unqualifiedly at this point, so sorry about that. It's just a question we don't have an adequate answer for today. So, but we will have that certainly well in advance of the 14th of August. Yeah, Susan,
And
yes. Yes,
The seller,
yes, yeah, right, Taylor?
yeah, the question was the seller's agent can get the entire commission if they assist a buyer that is unrepresented. They would just be the seller's agent, no sub-agency, correct? The
Yeah,
answer to that
yes,
is
and it's
yes.
an unrepresented buyer, and you can handle it two ways, just have an amount. Or the alternative is that additional amount, X plus some amount, if the buyer's unrepresented. Or Y without cooperating compensation. That's negotiable, all fully negotiable. Again, taking into account level of sophistication of buyers and sellers, that is gonna be different a year from now than it is today. But yeah, these are decisions. As long as we are making these decisions independently of our competitors, then we're gonna be okay. Yep. Two definitions of sub-agency. Maryland, a sub-agent is when an agent from another brokerage is working for the listing company. Yeah, well, there's only one definition of sub-agency. So, yeah, Steve, I'm not sure what that means. It's an agent from another company. Anyway.
All right.
All right, everybody. Sharon, I couldn't agree with you more. Looking forward to seeing this in the rearview mirror. And we will get through it. You guys have been great. Good questions. Just anything we did not get to, please let us know. If you want us to come out and do this in person at your offices, please let us know. All of our local boards know that we're available, so we're going there as well. And we're here for you. Just please know, a lot more coming from us in the next few weeks. And then this very big consumer campaign launching in August to demonstrate that we bring value to the transaction and we're worth it. And we work on your behalf. And hopefully that'll give consumers a little bit of a reason to keep using us. Okay. Thank you all for hanging in there. Over 100 people still on. So we really do appreciate you guys. And once again, let us know if there's anything else we can do. With that, we'll sign off.